this is the part 2 of the new code of conduct for the Philippine Judiciary. Okay, so this will be about disqualification and inhibition of judicial officers under Rule 137. Okay, so let's discuss those which are compulsory. Okay, because Section 5, Canon 3 makes an enumeration when judges should disqualify themselves. And these cases include first, actual bias or prejudice concerning a party or personal knowledge of the disputed evidentiary facts. Number 2 is the judge previously served as a lawyer or is a material witness on the matter. Number 3, the judge or a member of his family has a material interest in the outcome of the controversy. Number 4, judge previously served as an executor, administrator, guardian, trustee, or lawyer in the controversy. Number 5, that the judge's ruling in a lower court is the subject of review. Number 6, relation of the judge by consanguinity or affinity to a party litigant within the 6th civil degree or to counsel within the 4th civil degree. Number 7, the judge knows that his or her spouse or child has a financial interest as an heir, legatee, creditor, fiduciary, or otherwise in the controversy, or has any other interest that could substantially be affected by the outcome of the proceedings. What are the grounds for compulsory inhibition of a judge? Number 1, involving actual bias or prejudice. Like in the case of Umale vs. Villaluz, a judge inhibited himself from trying a robbery case due to his personal knowledge of the case. Number 2, economic interests of judge or his family. In October vs. Velasco, a municipal judge as private complainant caused 3 criminal complaints to be filed before his own court. He also issued a warrant of arrest and subpoenas before finally inhibiting himself from hearing the cases. So number 3, reviewing own cases. In Sandoval vs. CA, the Supreme Court found that an associate justice who only partly presided over a case in the trial court and who did not render the final decision cannot be said to have been placed in a position where he had to review his own decision, and as such was not legally bound on this ground to inhibit himself as ponente of the case. Number 4 is previously served as counsel. A judge may validly disqualify himself due to his bias and prejudice. Disqualification was also allowed when the judge had been previously associated with a party as a counsel, had notarized the affidavit of a person to be presented as witness, or if he was a material witness to a case. And for the last part of this video, we will discuss voluntary, those which are voluntary for disqualification or inhibition of judicial officers. Number 1, a judge may, in the exercise of his sound discretion, disqualify himself from sitting in a case for just or valid reasons other than those mentioned. Number 2, a judge may not be legally prohibited from sitting in a litigation, but when circumstances appear that it will induce doubt to his honest accusations and probity in favor of either party or incite such state of mind, he should conduct a careful self-examination. Number 3, a judge should not be disqualified because he was a classmate or a co-member in a fraternity of one of the counsels, if there is no proof that such a relationship results in actual bias or prejudice. Number 4, the mere fact that the counsel who is appearing before a judge was one of those who recommended him to the bench is not a valid ground for voluntary inhibition. And lastly, the objecting party to his competency may, in writing, file with the subject official his objection and its grounds. The said official may, in accordance with his determination of the question of his disqualification, either proceed with the trial or withdraw therefrom. So that's it. For the next video, we'll discuss discipline of members, officials, employees, and personnel of the judiciary.